Good afternoon. Welcome to the webinar, How the SRA Uses the Risk Framework to Deliver Risk-Based, Outcomes-Focused Regulation. My name is Caroline Hardman, and I'm the Technical Advisor for the SRA's Risk Centre. I'm responsible for the overall quality and regulatory sense of our evolving risk framework. I'm also involved in our ongoing programme of work to embed risk-based regulation across the SRA. I've been with the SRA for nearly 14 years, originally in an investigatory and advisory role. I've been involved with our development of risk-based regulation from the outset, playing a key role in setting up and running the SRA's risk assessment team, and more recently, the Risk Centre itself from 2010. I'm a member of the Institute of Risk Management and hold an international certificate in risk management. I'm joined today by my colleague, Tom Barcham.
Hello, my name is Tom Barcham, and I'm a risk analyst in the Risk Centre, a role I've held for almost 2.5 years. I work with colleagues on quantitative analysis, and we work alongside other colleagues in the Risk Centre who focus on qualitative analysis. I've been at the SRA for over 4 years, and in that time I've worked with colleagues from a variety of different parts of the organisation. Like Caroline, I'm also a member of the Institute of Risk Management.
So let's have a look at what we're going to cover in today's webinar. Before we speak specifically about the risk management process, we would like to talk briefly about the context in which the risk framework sits. We will then move on to consider the 5 steps of the risk management process, with particular emphasis on looking at risk identification and risk assessment. I will be talking about the SRA Risk Index, and Tom will discuss some of the risk assessment and methodologies that have been developed by the Risk Centre. Finally, there will be a question and answer session. Please feel free to submit your questions as we go along by clicking on the Ask button on the right-hand side of your screen. If you can't see the Ask button, you can come out of the full screen view and it will be there. 1 hour CPD can be claimed for listening to the webinar, and details of the code will be provided at the end of the Q&A session. If during the webinar you experience audio problems, please see your confirmation email for assistance. So before we discuss the details of the SRA risk framework, let's look at the context in which the risk framework has been developed. The ultimate goal of the SRA's regulatory activity is to work towards the regulatory objectives set out in the Legal Services Act 2007. These include familiar objectives, such as promoting and protecting consumers and the public interest, but also perhaps some less familiar objectives, such as promoting competition and increasing understanding of the public's rights and duties. To achieve these objectives, the SRA has committed itself to an outcomes-focused approach to regulation. This means that we will define the desired regulatory outcomes we would expect to see if the legal services market is operating in line with the intent of the Legal Services Act objectives. We can then measure the extent to which we are meeting these regulatory outcomes to gauge how well we are delivering against the objectives and assess our performance as a regulator. We are also committed to being a risk-based regulator. This means we will identify the risks that could prevent us from meeting the regulatory objectives and manage those risks to enable us to target resource to deliver the right outcomes. So in summary, our goal is to operate in line with the regulatory objectives. To achieve this, we have adopted an outcomes-focused, risk-based approach to regulation. And it is the framework, the risk framework, that sets out how we will manage these risks to achieve the right outcomes. So let's now look at the risk framework itself. The risk framework was published in December 2012 and is available on our website. This diagram shows the SRA's 5-step risk management process, which outlines how we will identify, assess, monitor, control, and evaluate risks to deliver the right outcomes. By aligning our regulatory activities to the risk management process, it provides us with a joined-up view of the risks that the SRA manages. It also provides us with an aggregate view of exposure to regulatory risk and how effectively we are managing each of these risks. So let's have a look at the 5 steps of the risk management process in more detail. The first step is identification, the starting point for any regulatory activity we undertake. To assist us identify risks in a consistent and organised way, we have developed a central risk index which sets out all the risks we have identified which may prevent us from meeting the regulatory objectives. This index provides structure and a common language for use across the SRA and also for external communication. The index was developed following extensive consultation and a number of workshops where we asked staff from all areas of business to identify the risks they see in their day-to-day roles. The exercise resulted in over 200 risks being identified, which have been distilled into the risk index. The risk index has 6 high-level risk categories, which you can see on the left-hand side of the table. The 6 high-level categories are underpinned by 43 level 1 risks, examples of which are given on the right-hand side of the table. These level 1 risks provide further details about the high-level risk categories. The first risk category is firm viability and structure. This category includes risks arising from firm instability due to events relating to either their financial viability and/or their structural composition. Examples of the type of level 1 risk that fall within this risk category are financial difficulty and group contagion. Financial difficulty is where a firm experiences difficulty in meeting its ongoing financial liabilities. This is a risk that is currently very topical. Group contagion is an example of a new type of risk we may see emerging from an alternative business structure with a large corporate arrangement. It is where liabilities, losses or events affecting one part of a group affects the regulated legal firm within that group. This risk could also arise in a group of firms with a common branding, where there are reputational links. The second high-level risk category is fraud and dishonesty. Examples here include criminal association, that's the risk that a firm or individual becomes involved with a criminal organisation or group, and intentional misleading, the risk that a firm or individual acts in a way which is intentionally deceptive. The third high-level risk category is firm operational risks. These are risks that arise from the inadequacy of a firm's policies, processes, or procedures. Examples of the type of level 1 risks in this category are breaches of confidentiality and poor standard of service. The fourth risk category is competence, fitness and propriety. This category covers the risk that an individual or firm lacks the required skills, knowledge or behaviours, fitness or propriety. This category includes level 1 risks such as discrimination and a lack of financial competence. The fifth risk category is market risks, which are risks arising from or affecting the operation of the legal services market. This category includes level 1 risks such as competitive constraints the risk that the market is not operating freely, and also the lack of adequate training provision in the legal services market. The final high-level risk category is external risks, which are those risks arising from wider factors beyond the scope of the legal services market. Examples of level 1 risks in this category include economic changes or public emergencies that may impact on the legal market or legal services providers. The first 4 of the high-level risk categories relate to risks that arise within a firm or from individuals working within those firms. Market risks arise from outside a firm, but from within the legal services market itself, whereas external risks arise from outside both the firm and the legal services market. The index is a dynamic document, and we will be regularly reviewing it to ensure that it captures new emerging risks and reflects any changes to existing identified risks. The most up-to-date version of the index can be found on our website. The second step of the risk management process is risk assessment. And Tom is going to talk about what this means and the tools the Risk Centre have developed to assist staff carry out this step.
I'm going to discuss in more detail 2 of our main areas of risk assessment: assessment which relates to firms and assessment which relates to events. The approaches I'll discuss here are in use at the SRA today, and I'll also touch on some of the developments that we are making. I'll begin by speaking about firm risk. Firm risk is measured by 2 components. Firstly, we have a firm's regulatory footprint, which establishes the potential of a firm to impact on the regulatory objectives. The second component is the firm's probability of having a risk crystallise, essentially the likelihood of issues arising that may require regulatory involvement. These are both currently data-driven and are calculated in different ways. Bringing them together helps to determine how a firm is supervised and the risks that we may engage with a firm about. Thinking firstly about firms' regulatory footprint, we recognise that a firm's potential to affect the regulatory objectives can be measured in a variety of different ways. We use information available to the SRA which tells us about the characteristics of a firm that we believe influences their potential to affect the objectives. We use a combination of data to allocate scores and bands to every firm to reflect this. This does not relate only to the financial or the personnel size of a firm, but also to the types of work that a firm undertakes. So what are the types of data that make up the footprint scores? There are 4 main components that we use data for in our footprint methodology. Firstly, there's size. Firm turnover information and the number of fee earners provided each year by firms are used alongside current branch information to establish the size of a firm. An overall score for firm size is made up from these 3 aspects. Secondly, does the firm hold client money? This is a simple yes-no statement, with firms that do hold client money having greater potential to affect the objectives than those that do not. Thirdly, does the firm provide work for vulnerable clients? We use work category information, again provided annually by firms, to establish whether each firm is involved in work for vulnerable clients. This includes areas of law such as immigration and mental health. We also take legal aid into account when we calculate vulnerability scores. Finally, does the firm work for clients who are in a position of informational asymmetry? Once again, we use work category information to establish whether the firm is involved with work types where a client may be in a position of informational asymmetry. That is, where a client may not be able to judge whether they are receiving a good or a bad service, for example in residential conveyancing. We weight these 4 areas and generate an overall score for all firms of between 1 and 100. We then draw thresholds using these scores to determine which firms are high impact, medium impact and low impact. Generally speaking, around 200 firms are regarded as high impact and tend to be relationship managed, with around 2,000 firms being medium impact and the remainder classed as low impact. A firm's footprint has no bearing on how likely it is for a risk to crystallise. It's simply a statement that if such a firm did fail, what would be the potential effect of this? We're currently making some improvements to the footprint information. In particular, we are redefining this measure to align it to the regulatory objectives by considering the groups who would feel an impact of a risk in a firm. We will also be using new data to feed into our footprint models. For example, the more detailed client money information that firms provided at the most recent renewals exercise. Finally, we'll be introducing a new concept to our footprint methodology with the measure of severity. Severity scores will be allocated to all firms, and these reflect to all risks, and these reflect their relative seriousness. We'll be using the firm's footprint to quantify the maximum potential impact of a firm, and then we'll use the severity scores for each risk to allocate a proportion of the firm's footprint that may be affected. This combination of footprint and severity will give a better comparison across risks in a firm and of risks across firms relative to one another. Once we've established the overall footprint, which tells us about the impact that could be felt by a risk crystallising in a firm, we consider how likely it is to occur. This is our probability assessment. A risk that, should it arise, would have a considerable impact, but the potential for it to occur is minimal, may lead to a different engagement approach to a risk that has a smaller impact, but a greater likelihood of occurring. We use firm characteristics, both structural and regulatory factors, which have a correlation with risks occurring, to achieve this in order to identify indicators affecting the likelihood of risks arising. So how do we establish probability? We use historical information about risks that have crystallised in the past and the characteristics of firms in which those risks arose. We've tested a wide range of characteristics to establish whether they were statistically significantly more likely to occur in firms where risks did crystallise than in those firms where they did not. Once established, we use these characteristics as our probability indicators. Where these indicators are present, a score is allocated to a firm in one of the 4 high-level risk categories. We draw thresholds using the scores for each category to determine risk ratings. Each firm therefore has 4 probability ratings, 1 in each category. In establishing probability profiles, we use data that is already available to us, including new information that has been requested in recent years. As we learn more about the characteristics that influence risk levels, we may ask for new information from the firms that we regulate. We're looking to improve our probability assessments by analysing risks at a more specific level than those 4 headline categories. We're currently doing work to provide probability analysis at a greater level of granularity, specifically using the level 1 risks in the risk index wherever possible. To achieve this, we're using new quantitative analytical techniques to understand the effects of different firm characteristics on different risks. We are also building qualitative analysis into our firm-level assessments, which is particularly important for the risks about which we hold little data. Footprint and probability data is used in practice by the SRA in several ways. The SRA uses footprint data to determine our supervisory approach. As a regulator with limited resources, we can't actively supervise every firm in the same way. So we allocate an approach to supervision based on the firm's regulatory footprint. Generally speaking, this means that firms who have a high footprint score are relationship managed. The probability assessment helps to focus our activity within supervision and authorisation on key risk categories where our work can have the greatest effect. Probability information in particular gives supervision a starting point for their own work. The probability analysis by the Risk Centre is not seen as determinative, for it's based on the limited information that we do hold, but it does identify lines of inquiry for supervisors to pursue. Frontline staff often have a lot more information they can feed into their own judgments about which steps are appropriate to take. As well as being used to prioritise firms, footprint and probability analysis of aggregated risk profiles allows us to understand different risks posed by different parts of the firm population. For example, we use this data to compare the risk profiles of subsets of the firm population by work category specialisation. Alongside firm assessments, we have the second part of risk assessment, which relates to events. Event notifications that come into the SRA are an important source of information about risks in the regulated community. This information is assessed in its own right, using a different methodology to that for firms, but still underpinned by impact and probability. Events originate from a range of sources, including firms' own notifications about where issues have arisen, and reports and intelligence received from the public, the regulated community, the Ombudsman, and from law enforcement agencies. On average, we receive over 1,000 pieces of information each month, and we employ an assessment methodology to prioritise and to action this information. Consistent assessment of this information is important to prioritise the things we look at, and the decisions of supervision and other parts of the SRA to act on the events will depend on this assessment. When we assess an event, we look at a number of factors. Firstly, we classify the event. These classifications are varied, with around 180 available to assessors to select, in order to accurately categorise the nature of the event that's reported. By selecting a classification, assessors are allocating the event a score which reflects the seriousness of the issue. This is supplemented with an assessment of the impact of the event. This could take into account the number or the types of clients who are affected, or the financial sums involved that affect the event. Thirdly, an assessment of the source of information is used, and the strength of the evidence supplied. This helps to establish the probability of the event that is being reported reflecting actual events. These three components, the classification, the impact and the probability, are multiplied together to generate a total score for each event that is reported to us. These scores are translated into red, amber or green ratings, which help to determine what further action or investigation will take place. Decisions about next steps for an assessment are made in conjunction with other things that we know about a firm. This form of event classification has been used by our risk assessment team for some time. However, we are looking to develop it further by including an assessment and association to the level 1 risks in the risk index as part of that assessment. That covers what risk assessment is for firms and events, but what is it not? Risk assessment is not the answer to all the regulatory challenges that the SRA faces. It's a tool that our frontline staff can use to inform their decision making, and it is not a substitute for their own judgment. Our risk assessments of firms and events provide contextual information that could be coupled, for example, with knowledge of a firm that an individual supervisor may have. After the assessment stage, we move on to monitoring, which Caroline is going to speak about.
So we have identified the risks against the risk index and then measured the size of the risk by undertaking a risk assessment. We now need to determine whether we need to take any action. This will be guided by our risk tolerances, which provide thresholds against which action can be consistently taken. Risk tolerances are set to ensure that our limited resources are targeted at the greatest risks, or those risks upon which action will have the most effect. If the risk is within our tolerance, we will continue to monitor the situation, and if further information is received, about that same risk, it will be reassessed to establish it still remains acceptable. If risks have been identified and assessed as being beyond our tolerance, we will move to the next stage of the risk management process, risk controls, and consider what action to take to mitigate the risk. We may employ controls at different levels. They could be addressing risk in a firm, with an individual, or thematically, for example, across a sector of the market. The purpose of such controls is to mitigate the level of risk by reducing the likelihood of them arising, or by minimising the impact that they have should they occur. We have a broad range of regulatory tools and powers available, which we can employ to mitigate risks. Examples of our regulatory controls include interventions. These are used in the most serious circumstances, where clients' interests need to be protected. Formal decisions to fine or reprimand. This may be by the SRA or the Solicitor's Disciplinary Tribunal after a referral. Informal engagement. This may take place by supervision or other parts of the SRA to control risks in a more collaborative manner. Letters to the regulated community. Letters and other forms of guidance can raise awareness of growing or changing risks at a sector or market level and provide firms with information about how to mitigate them. For example, guidance on the recent referral feedback. And finally, policy setting. We may feel that changes to the handbook or other policies are required to control particular risks. We use the most appropriate controls in each situation, and it is dependent on the risk posed.
The final step in the risk management process is evaluation, learning and adapting. This step is important in helping us to identify what is working well in the risk management process and what can be improved. Our evaluate, learn and adapt step helps us to judge the effectiveness of the risk management process and how it's operating in practice. The risk governance that performs this function is provided by three key groups. Our tactical risk group, which addresses more operational matters, our strategic risk group, who make decisions about resource allocation on the basis of risk, and the non-executive regulatory risk committee, which oversees the delivery of risk-based regulation. These groups identify potential improvements to the risk management process and ensure that the desired outcomes are achieved. These groups are also responsible for ensuring that proportionate responses are taken to control new or changing risks. These groups, in different ways, have a view of and make decisions around the following three things. Risk exposures and tolerance. For example, trends of different risks and where steps need to be taken to address them, or specific escalated risks and events that are outside our tolerance. Secondly, the controls that are used to mitigate these risks and a view on their effectiveness, changing controls where necessary, including policy change recommendations. Thirdly, information on outcomes to assess the overall effectiveness of the risk management process and to help judge where changes may be required. Where changes are made, they are fed back into the identification stage of the risk management process, where they are used in practice and their outcomes can again be evaluated.
Thank you, Tom. So there you have it, the 5 steps of our risk management process. Firstly, before acting, we identify risks against the Central Risk Index. Secondly, we assess risk consistently to measure the size of the risk. Thirdly, we monitor risk levels against our tolerances to determine whether we need to take action. Fourthly, we control unacceptable risk levels through application of our regulatory tools. And finally, we continually evaluate our effectiveness and learn and adapt our approach accordingly. I hope you found the webinar useful. We are now available to answer any questions you may have. If you'd like to ask us a question, you can click on the Ask button on the right-hand side of the screen.
We've had a number of questions come in already. One of the ones that's cropped up several times is people asking about whether they can see their profile scores. At the moment, there aren't any plans to share the profile scores with firms, whether it's the impact or the probability. And this is fairly standard practice for regulators. The footprint and the probability scores in isolation are not really that informative or meaningful. And it's only placed in the context of other firms that they have meaning. One of the reasons we've chosen not to share this information is that the scores also change on a regular basis. And it would take a lot of resource to share all this information with firms on an ongoing basis. In the same way, information about the indicators as well isn't something that we currently disclose. They're largely based on structural and regulatory data that actually firms can do very little about at this stage. It's worth noting that the profiles and the event scores as well aren't in themselves the final decision about what action is taken. Instead, colleagues around the SRA use this information in conjunction with other information that they have to hand to decide how a firm is supervised. It should be noted, in the coming months we'll be publishing a paper which outlines the evolution of our approach to risk assessment, and this will include reference to how we hope that more information can be shared with firms in the future.
We're also getting a couple of questions in, from particular Samantha and David, about the event classification and whether that is actually published. The actual classification itself and the methodology for event assessment, risk assessment, is on our website. If I recall rightly, it gives an example of the type of scores that are available in that assessment. But if you'd like to actually email us, we're quite happy to provide you with a copy of the actual full event classification scores. You can email us at risk@sra.org.uk, just specifying that you'd like to receive a copy of the event classification, and we will send that to you.
We've had some questions about why we've asked for more information about client money at the most recent round of renewals. Law firms are sort of fairly unique in that quite a large majority of them hold client money, and this poses a risk to one of the main objectives that we have, so protecting the interests of consumers. Our current footprint assessment is just based on a yes-no, does a firm hold client money, either they do or they don't. And so only with that information we can't differentiate between those differences between firms who hold more or less. And in particular we know that firms who are seemingly quite small in terms of the number of personnel may actually hold large amounts of client money and vice versa. With this new information about client money that's been provided at the most recent renewals, we'll actually have a more comprehensive picture of where client money is being held. For our footprint methodologies, this means that we'll be able to allocate a more proportionate score to firms based on the actual amounts of client money that they do hold, rather than needing to use a simple yes-no approach, which is currently being used.
We've also been asked about the actual risk index itself, and somebody is saying, I'm interested in that it actually only lists the level 1 risks, and that is absolutely right. If you go onto our website and go into the actual risk index itself, we do have the level 1 risks and also some examples of what those level 1 risks are. It is a bit confusing to actually say that there's level 1 risks. Originally, when we put the risk index together, as I explained, the process that we went through to devise the risk index, we actually captured over 200 risks. And initially, we had level 1 risks, and then also level 2 risks, which were further details of the risks that were in those high-level risk categories. But we subsequently decided that actually we needed it to be quite simple and it needed to be clear for people at this stage. So we decided to go with just the high-level risk categories and the level 1 risks and give some examples of the sort of other issues that might actually fall within that those particular risk categories. Those examples aren't in a printed copy of the risk index, but you can find them in the copy that's on the website.
We've had a question about a recent survey that we put out and how that fits into our methodologies. We sent out a severity survey to the profession, targeted particularly at compliance officers a couple of months ago, which asked people to fill in a short survey based on using the risks that are in the risk index and asking how people might prioritise them. As I mentioned before, we're starting to introduce this new severity component of our calculations, which will help us to understand the relative seriousness of different risks that we have in the index. What we're doing is we've had a series of questions, the same sort of questions being asked to members of SRA staff who are experienced and understand a wide range of those risks. We sent the same survey out to the profession, and we're going to be using a combination of both sets of those results to give us that final set of severity scores that we'll be using going forward. We acknowledge that some of the risks in the risk index may change over time in terms of their seriousness, and there may even be new risks that come into the risk index over time as well. And so we may rerun that survey in the future, potentially including other groups as well. We'll be publishing some results from that survey, that external survey that is due to close fairly soon in the coming months.
We have a question here from Andrew. He's asking, in assessing the risk profile of a firm, do you give any weight to membership equality marks such as the Law Society, Quality Conveyancing Mark or Lexel accreditation? Now, it's my understanding that we don't, Tom. Do you want to just clarify that a bit? We did look at it, didn't we, for slightly whether it could be something we could include as an indicator.
Yeah, at the moment, those two particular things don't feature as part of our indicators. However, I explained how we're evolving the risk assessment methodology, particularly for probability. And as we start to understand these new characteristics much better and collect more historical data about them, we may start to find that they do have an influence on whether a risk is more or perhaps less likely to occur in a firm. So at the moment they're not being used, but there will definitely be things that we will be examining as we continue to evolve our methodologies.
We've got a question here as well about whether we profile individuals, risk profile individuals. The answer is no, we don't at the moment. We do put some information into the firm profiles about the individuals who work within the firm, but we don't actually profile the individuals themselves. But it is something that we'd be interested in looking at in the future. In particular, we would be interested in people who move from one firm to another and create problems at different firms. So potentially risk profiling individuals would actually assist with us identifying concerns in that area.
There's another question that's come in about whether we will be increasing the amount of information that we ask for in the future. As I mentioned in the last answer, our understanding of how characteristics affect different levels of risk is still growing and still changing as we collect more information. But we think that yes, in time, we will be asking for more pieces of information from firms. We recognise that the time and cost that's associated with providing this data, and so we're also assessing the current information. We will be assessing the current information that we ask firms to provide, and where we find that there's actually no risk characteristics that we can use that information usefully for, we may no longer require firms to provide that to us.
We've got a question here from Duncan asking if there is a whistleblowing procedure a firm can use where it is dealing with another firm where it becomes clear that levels of competence and professional etiquette standards are not being adhered to. We do have a whistleblowing policy, but that's about actually whistleblowing within your own firm. If you wanted to report concerns about another firm or individual, you can make that through making a report through our website. This will actually come into the risk assessment team, who will then apply that risk assessment to, classification to it and undertake the risk assessment, and it will be forwarded on to the relevant unit.
Got an inquiry about, I mentioned during we both mentioned during the webinar how supervision are using this information, but an inquiry about how authorisation are also using the risk assessment information. In terms of the authorisation of firms, we still use that impact and probability concept to help prioritise work and to decide which things need to be looked at into more detail. So the impact calculations that I explained, which incorporate the size, the client money, the vulnerability and the informational asymmetry aspects, that's all used as part of our consideration when we're authorising firms. The probability assessment is slightly different in that it relies more on the information that's provided in the application and the direct dialogue with applicants. So there'd be no risk assessment that's calculated during the authorisation steps.
Somebody has asked how they know if they've been allocated a relationship manager, or does every firm have one? The answer to that is you know if you have a relationship manager because somebody would have contacted you and introduced themselves to you. So no, every firm doesn't have one. If you remember when Tom talked about how we use the footprint of a firm to actually put all firms into three categories, either low impact, medium impact or high impact. And it's those high impact firms that actually have relationship managers attached to them. I understand there's about 200 firms in that category at the moment.
And we've had a question from Andrew about whether we publish our event classifications. I think, as Caroline mentioned earlier, that information is available on the website. But just to add to that, we'll be releasing more information about our overall approach to, also the evolution of our approach to risk assessment in the coming months as well.
We've had a question about what is severity and how that actually links into the survey that somebody's filled in. I wonder, Tom, if you'd like to talk a little bit about that.
Yeah, in terms of the severity, so I mentioned that we're going to be using that, the responses from the external survey along with the internal survey to help us reach an overall score. But just to summarise what severity is, at the moment, we have no weightings between those level 1 risks that are in the risk index. What this means is if we apply the same footprint and probability scores for, say, money laundering and misleading publicity, we will get exactly the same results at the other end of the analysis. The severity scores are an acknowledgement that some risks actually have greater potential to harm the objectives than others. And so with these severity scores, we're effectively saying some risks are more serious than others, and this will help to sort of create scores which reflect that when we're undertaking firm level assessment. It's going to ultimately give us a better prioritisation of things that we can act on.
That's great. Well, we've answered all the questions that have come in, Tom, believe it or not, or the majority of them anyway. Is there anything you'd like to add, or?
I don't think so, no.
So thank you very much, everybody, for joining us.